episode about one of the most insane political assassinations in my entire lifetime for $300,000 with Andrew Wilson. I don't understand. What do you mean? There's so many reasons why this is an interesting thing right now.
Peaceably, or people are going to be banging down your door. He was a undercover cop, which I don't like that. I don't know what he did undercover. It's very hard to find anything about Mike Mitchell, but he worked with them for 20 plus years, the police officers. The reason why Tyler Robinson knew him was because he lived nearby and he was also his Boy Scout leader.
How does this negate that the parents could write this second? And by the way, if you have the evidence,
that point. I'm just saying that your first point, which is that the parents did this.
Yeah.
We don't know that the parents.
I didn't say that they did ever.
Well, you're quoting the parents as having said. You said that Matt Robinson said that his kid was. You say involved. I don't want to misquote you.
Confronted him.
It's funny too because what's happening here. It's what's really in a very queer sense, in a very mutated sense. What's happening here is Andrew is playing the role of prosecutor, trying to prove his case beyond a reasonable doubt, and Candace is playing the role of defense, where she's just trying to poke holes in his theory, right? That ideally, remember, in a criminal court, you're trying to convict somebody so that no reasonable person on the jury could have a reasonable doubt in their mind as to whether or not the defense, the accused, actually committed the crime. It's not 100%, but like there can't be another reasonable explanation that could exist that could explain away the defendant's behavior or that could put him in another place, right? That's essentially what you're doing, right? However, that's not what this debate was supposed to be. The debate was supposed to be both of them have a theory on why, on how Charlie Kirk was killed. He believes the official story. She purportedly believes in a conspiracy. She has not defended her idea at all. She's only playing defense against his theory. She hasn't offered any of her own. Now, this is 2 hours, 60 minutes. Okay, there's still a lot left. But hopefully he realizes that, I guess, or something, and gets her to put her theory out there. Otherwise, all she has to do is poke holes in his story. It works for her, you know?
Well, you're quoting the parents as having said, you said that Matt Robinson said that his kid was, did you say involved? I don't want to misquote you.
Confronted him about it.
Confronted him.
Yes.
And I'm telling you that we have not seen any evidence that that is true.
We can fact check that.
Okay.
Because we do have evidence.
And I'm saying it's the charging doc, which could have been derived from a statement Mike Mitchell said.
Two things I have ready in the back. One is the charging doc, and the other one is a video of Kathy Nestor saying she hasn't seen Tyler's phone.
Okay, we can run Kathy to go back, and then just go backwards to, Kathy first in court saying she didn't get her client's phone. Yeah, and then I think we'll go to the, if you're okay with that.
Thing not in dispute. These are all things that are not even disputed.
Okay, so we don't show it.
We never get to the thing that I am disputing.
Well, I was just providing an answer. We were coming back in from a break because you were talking about the text messages, something that you felt was concrete. So it was just my rebuttal to you. That's not concrete because they haven't had a chance to actually answer that, and she didn't even get to see your client's phone. So that's effectively, again, the state saying these messages are real. You don't get the discovery on these messages just yet. She will during trial. They will actually
Don't
discover
you think
the messages.
that would make their case fall apart if it was the case that they weren't able to actually pull the data off the text messages? Do you think the prosecution would go to court with fabricated text messages?
It's called winners and losers. They may not be fabricated. But by the way, as what they are saying, like I said, if there was somebody logged into his phone, they may not be fabricated. That's
okay.
the point.
So let's get to
the
parents fact check.
So I was saying, I believe what you're talking about was derived from the charging doc, which was signed off by Brian Davis. Let's see if that's correct.
Oh, man.
What are we looking at
Robinson's mother explained that over the last year or so, I'm sorry.
Can you zoom in a little bit?
Is this the charging doc?
I can see it. Robinson's father reported that when his wife showed him the surveillance image of the suspected shooter in the news, he agreed that it looked like their son. He also believed that the rifle that police suspected the shooter used matched the rifle that was given to his son as a gift. As a result, Robinson's father contacted his son and asked him to send a photo of the rifle, which makes sense with the text messages. Robinson did not respond, however. Robinson's father spoke on the phone with Robinson. Robinson implied he planned to take his own life. Robinson's parents were able to convince him to meet at their home.
Yes, so this is proving my point. This is from the charging document, correct? Yeah, so what I'm saying to you is that 3 people got interviewed on that night. Mike Mitchell got interviewed, Amber Robinson got interviewed, and Matt Robinson got interviewed. Of the 3 of them, only one of them actually wrote a statement, which was referred to in this preliminary trial. He came in, I believe, in March, Mike Mitchell, and he wrote a statement, which I find to be very shady that they decided to bring.
But why aren't the parents disputing that?
Well, first off,
that's the question.
First off, the parents are not going to ever play in court, play to the cameras in court when they have a legal team that is going to be advising them not to speak to the court because your son could go to prison
forever. But they're playing to somebody else who's your source?
I'm not going to address that.
They're playing to someone else who's your source, but won't go publicly tell the media this is not true?
Well, what I did not say to you that I just said I have a source, so I want to be very clear and take it from somebody who is involved and permanently sued. When I have to take my lawyer's advice, I mean, there's so many things I want to respond to when people are speaking about.
Yeah, but it's bizarre that they would utilize a source which would get the information to you, but wouldn't just go to the media and be like, actually, that's all wrong.
I am telling you that if you would nary find a lawyer who would advise you to go to the media.
And this mother,
especially when your son was up for death.
If I thought that my kid was in any way, shape, or form going to be up, you couldn't shut me up. Or my wife, she would be like, that's not true. That's ridiculous. There's no possible. That never happened. These people are lying through their teeth. They'd be public whether you like it or not.
Yeah,
that's like a really, really, really bad point. You really shouldn't fucking say anything because especially Andrew and Rachel wouldn't, because as much as you might have some emotional response, like if a lawyer is telling you, like, you know, if you run to the meeting, you want to say whatever because you feel better with your kid, that's fine. But they might get executed now because of your recklessness. I think they would probably recommend for you to shut the fuck up, especially for criminal shit like this. I think they would say, don't say anything.
That's for you and your wife, but when a judge issues a gag order in a case and your son is up for death and your lawyers could be advising you that if you say anything you could blow the case, you would have a more responsible consideration.
I see.
And we're speaking opinion here. You're like, well, I wouldn't care. I'd violate it and I'd violate the judge's orders and see
But
what
I mean,
happens.
if you have a source, it seems like they're violating it with them.
I'm not speaking to a source, but what I'm saying to you is speaking just relevant to what this is. We have not seen any proof that that statement that is included in this charging document, I think it is highly likely on the basis of the preliminary hearing that all came from Mike Mitchell. And Mike Mitchell would be a part, he's
Based
saying,
on the statements of
well,
the
it's him
parents.
saying the parents told me this. The parents could dispute that. That's going to come down the line, right? They're going to be able to seat the parents. I will say this, putting together context clues. If the state had it on, 100% certainty that Matt Robinson and Amber Robinson said it, a 5-day preliminary hearing would be a good time to say we have enough evidence, and I can tell you why Matt Robinson made this statement, and here is his statement that he signed. That would have been a good time to present that evidence.
That would also be a
your
good
side.
time for the defense to say this is totally
No, it's
fabricated.
not. It's the wrong time.
Why couldn't they?
That is completely the wrong time.
Why couldn't they?
Because what they're doing is they already said they didn't receive discovery. They literally can't. They literally can't because they can't. They did not
You're saying
receive
that they
discovery.
didn't receive that information?
No, they just received the text messages. But in order to
That's not the text messages.
the probative information.
Yeah, we're talking about the information that we just reviewed. That's not the text
They
messages.
never presented it. The state never put it on.
Yeah, they didn't. The defense could easily still have presented this. Yeah.
No.
They could have.
The bitch is dangerous because you can know literally everything about a topic, and she will confidently make shit up. Destiny, I don't think there's any way to come out of Candace's debate as a clear winner. Oh, no. You absolutely could, 100%. If you actually know, like, if you're familiar with the substance of the thing, you absolutely could, for sure. 100% though.
Said they're they're not allowed to. Are you sure?
In a preliminary hearing,
Yeah.
the defense is engaging with whatever evidence the state decides to put on. They did not put this on as evidence. Brian Davis was up there.
So they're not allowed to present anything?
They're responding to the state's
I'm asking,
evidence.
are they allowed to present anything?
They are allowed to
Like
say.
if there was a conspiracy that they could prove right then and there, would they present that in one of these hearings?
No, it wouldn't be the right time for
I
that.
disagree. I think
It's not
that
disagreement.
they not only could do it, but they would do it. In fact, when I talked in depth with my attorney, they said that's exactly, if you had actual evidence that there was fabrications by the feds, that's exactly when you would introduce that.
So when in the document that they filed yesterday or a couple of days ago, the appropriate, like what you're doing at this stage of the hearing is the state is saying we have enough evidence that we think this needs to go forth to trial. Hence the reason why there's this extraordinary, we allow hearsay because it doesn't really need to be perfect. It can be enough that we feel like we can move forward, right? And okay, I disagree with that in general when somebody's running in prison, but whatever. The next phase is for them to meet in court and for the defense to essentially present an argument to the state that says, we find this filing to be defective in and of itself. We don't even have to defend ourselves because you, the state, have enough, you know what the laws are on the books, and this filing is effective, and you should get rid of these charges because they don't make sense based on what you can decide based on the law on the books. So then that's why they then file the dismissal, right? So in the dismissal, what they're doing is they are engaging, and this is what was widely misinterpreted.
Well, yeah, they're engaging as though as it's a hypothetical. If this is hypothetically true, then
so they're
X.
saying all of
yeah,
these
but
charges.
I'm not disputing any of that.
So that's what you're asking. Why you're saying could they
no,
just
what
put
I'm
on?
asking specifically is like who could shut parents up who are like, no way, there's no possible, this never happened, this is ridiculous. They would be shouting it on CNN. They would be shouting it from the rooftops. They would be losing their minds. And you're like, nope, the gag order would be enough to keep them quiet. Not enough for them to talk to your source, but enough to keep them quiet. I think that's quite ridiculous. But I'll even concede this whole point to you. Let's just say maybe this was misconstrued, right? If there's a little bit of reason to doubt it because we're still waiting for the evidence for trial. If that's the case, then why not take the same standard for the evidence that you present? You're just waiting for trial.
Well, you didn't do that.
Wait a
So
second.
we're here.
Wait a second. I just want to make sure that I got this right.
Why would you wait? Why would you not wait? Well, Andrew's not the prosecutor of the defense, no? Like, he's got a lot less
That's
at
your
risk.
argument to me, right?
My argument to you is what?
My
Sorry.
argument, your argument to me is that, hey, wait a second, Andrew. There's not enough here that convinces me, right?
Well, that's actually my rebuttal to you, is that you are saying, why are people engaging in what you term to be conspiracy theories?
No.
I term it to be thinking. They're just thinking because they're recognizing there are a lot of holes in these stories and that this is not strong evidence, right? This is the reason they're doing it. I'm explaining to you this is the reason that they're doing it. I'm addressing what you view to be overwhelming evidence. And by the way, I want to be clear.
That would
what
convince
you're, what, yeah, well, but thus far,
And this is just like,
every
that's-
point
that
that you've
doesn't
brought up,
convince you.
every point that you've brought up, did you feel like this is beyond a reasonable doubt? I mean, you realize
Remember what I said in my
he's
opening.
going to be.
It's not beyond a reasonable doubt. It's just what I find convincing. It's what I find overwhelming.
So
He
why-
should have had a better standard. Like, what I find convincing is 51%. I don't know, more likely than not, it's convincing. But that wouldn't be good enough to probably win this debate for Candace Owens or even in the eye of a viewer.
Why are you so upset when people say they don't find it
If
convincing?
that was the limitation of the claims that you made, if it was just, wait a second, there's a little bit of problems.
But it's also like, dog, this is a $300,000 debate. You guys didn't kind of iron out what the goal was for this ahead of time. You're just like, oh, no, hold on. Let me be clear what I even am saying or what I'm even trying to present as a story here. Like, how do you not have this figured out a little bit more ahead of time? No? Hello?
problems in this case that I have questions for that I want answers to. Nobody have a problem, actually. Least of all me. I would be the least likely person to have an issue with it, you, any of your fans, anybody saying. In fact, I've had tons of Discord calls about this. My position's always been clear.
What's Discord?
Of course conspiracies exist. Some of them have way better evidence than others. But I've seen them myself. I know conspiracy. In fact, the federal government has hundreds of thousands of laws about conspiracies. They see them everywhere. We both know this, right? That's never what the problem is. The problem is when you make claims outside of, well, wait a second. I'm just questioning evidence here. I'm just questioning what the state's case is here. I'm just asking questions. It's when you make claims outside of that, where you claim that there's good evidence or good standards you should believe because, and then it's
Like he's trying to retreat to like kind of the standard philosophy argument and everything of like, oh, well, let me kind of like re-summarize, or let me summarize where we're at and then kind of try to catch up again. And it's like, Ken is a conspiracy theorist who is also very smart. So she will do the bad faith thing. Okay, she will twist and contort however much she needs, but she's also a conspiracy theorist, so she does have some facts at her disposal. And if you don't have a strong command of the facts, or at least a strong command of the law, well, I don't know what, I just don't understand why Andrew wouldn't prepare more for this. This is an expensive debate, and it's a big point in his career. Why would you not prepare for this?
Turns out that it's all nonsense, or it's wackadoo stuff, or it makes no sense. And when we have a chance to cross-examine your evidence that you presented, I'm going to show a lot of that. A lot of this conjecture that based on literally nothing, that leads from no inferences whatsoever. Like, you couldn't even infer it logically. That's the problem. The problem has never been whether or not you just said, you know, there's not enough in this case so far until we get to the trial. I remain unconvinced. I'm sure there's tons of people who remain unconvinced yet until we get to the trial. I think that's fine. I think it's fine there's people who are convinced, too. That's never been...
Like, another interesting thing that they could do, and Andrew and I have bet before, Andrew should have propositioned her with some kind of a bet with odds. Like, if you're very confident in your position, and now it's difficult because he's already given her $300,000 to do the debate, but like, how about a $10,000 bet with 5-to-1 odds, I guess? If you think there's like an 80% chance or whatever that he'll be convicted, like, why not offer her a bet with odds and then see if she'll take it to test the strength of her convictions with an actual number, you know?
My problem is the claims which are external to that.
Okay, I'm not sure I really care if you have a problem with what I think in my own spare time. I don't understand this like lecture that you just gave. But beyond that, what I'm saying is that
What
the state
lecture?
is allowed to use.
I didn't
This is
lecture
what
you.
my problem is. You guys are not allowed. Yeah, you guys think while it's illegal. You can. You are allowed to do that. So, but anyway,
Nobody said you can't.
going back to you saying I wouldn't have a problem. I think I just demonstrated pretty thoroughly that what you claim that you have a problem with is exactly what the state is engaged in at this stage. So it just doesn't make sense.
That's not the case. In fact,
So
the
people
thing
look
is,
and they say,
the thing
I'm
is
looking at the
funny.
gun and I see and I'm inferring this, and someone else says, I'm looking at the gun evidence and I'm inferring that. They're both doing the exact same thing.
They're not.
You're just saying, I want to do it for the state.
That's propositionally false.
That
and
is not
I'll explain
propositionally
exactly
false.
how.
Oh, man.
It is the case that every proposition is going to have a true or false conclusion, period. That's just logic, right? It's the law of excluded middle. All propositions are going to be true or they're going to be false. When we're making inferences, we're making inferences based on propositions. We can actually come to true conclusions with false premises inside of a proposition, in fact. What we're talking about here is not whether or not you feel that you're convinced by this evidence.
But you felt like you were
Right?
convinced.
Sure.
Like, he's trying to do a philosophy game. That's just not true. It is about how you feel about it. That's what a jury is there, is to feel. They're not there to logic lord it. They're not there to deduce, right? Funnily, we say in common parlance that you're deducing from some set of information, but you're not actually. You're inferring. Every human thought like this is an inference, because you cannot 100% know with absolute certainty any fact of the matter unless you're a direct witness to the fact itself. And then even that, we get into, epistemic theories of truth and what does it mean to observe a thing and know a thing to be true, blah, blah, blah. But all of these things are inferences at the end of the day. Unless you're debating math, okay? Unless you're debating math or you're debating some kind of deductively or something stemming from some axioms, from some set of statements that you both agree to be true, all of this is going to be an inference, right?
But here's the thing. When you ask me my reason, Andrew, why are you convinced by this? I can give you my reasons why I'm convinced by it, why it seems reasonable and rational to me to be convinced. You could even say, but Andrew, I'm just not convinced by it. If that was the limitation of your claims, we wouldn't even be having this conversation. That's why I wanted to have the conversation, in fact, was so that we could move into your actual claims that you've made, which transcend the idea of, I'm just asking questions.
Before we get into that, your team has one thing they want to show before you go into that. So if you want to pull that up, this is the prosecution filing showing defense had full discovery by April.
Oh no, he's got a team. He's got a team. Where have they been?
They did not. That's not true.
Wait a second.
Yeah.
To date, the state's prosecutors have disclosed all evidence that is presently and reasonably available to them as required under Rule 16, Utah R criminal, to be more precise as of April 1st.
Yeah, that was not 100%. That's why they're caging that by saying what's reasonable. There was
Precise as of...
Provided approximately 100%, they say. Okay, when you see statements like this that show up in legal filings, right? To date, the state's prosecutors have disclosed all evidence, quote, that is presently and reasonably available to them, end quote. And then they're quoting a local rule here of criminal procedure. This is the legal standard. That's what they're quoting. Presently and reasonably available. My guess is if we look up Utah Rules of Criminal Procedure 1682, it probably says that this is like your standard for the evidence you have to present. But you put these legal terms in here because it's would you say it's a term of art? Like it means something. that doesn't mean like for the layman like, oh, well, they're saying reasonable, so like maybe they were being tricky with the word and they withheld a bunch of. No, that's not how that works, because if they do, well, then you would challenge them on it, and if you win, you could get the whole case thrown out, or at least like parts of stuff they're trying to introduce into court.
Evidence that is presently and reasonably available to them, as required under Rule 16, Utah are criminal, to be more precise, as of April 1st.
Yeah, that was not 100%. That's why they're caging that by saying what's reasonable. There was entire, and we can pull this up. Like, we should now play the Kathy Nestor clip, because that's from there. So and they were basically saying you don't need it at this stage, meaning.
It's just like, why would you just like a little bit of law? Just learn a little bit. It's criminal procedure too. Civil procedure is supposed to be really tough. Criminal procedure is like crime shit that like ideally an average citizen should kind of be able to understand. Now we still get attorneys provided to us, but like it's easier than fucking contract law, or even a lot of tort shit is more complicated. Hold on, what was this? It's Utah rules criminal procedure 16A2. Okay, Utah rules criminal 16A. Utah rules criminal 16A. 2, or here. Presently, yeah. So they're quoting a legal standard here. Timing of mandatory disclosures, blah, blah, blah. In every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination, if applicable, or before the defendant enters a plea of guilty. Right? So presently and reasonably available is the legal standard that they're quoting. It doesn't just mean like reasonable, like up to their own, judgment.
Evidence that is presently and reasonably available to them, as required under Rule 16, Utah are criminal, to be more precise, as of April 1st.
Yeah, that was not 100%. That's why they're caging that by saying what's reasonable. There was
They're quoting a legal standard.
It's entire, and we can pull this up. Like, we should now play the Kathy Nestor clip, because that's from there. So and they were basically saying you don't need it at.
But Andrew doesn't even know this, so he can't counter. He doesn't have the facts or the process of the procedure. He doesn't have the specific facts or a macro understanding of just the law.
Stage, meaning it's not reasonable.
When I say macro too, I just mean like basic stuff.
That you're asking for this, and we're going into a hearing that's just going to be based on hearsay and stuff, things of that nature. But of course, by the time a trial comes, you're going to get all the
Where's
discovery
the show
documents.
cause?
Yes.
Yeah.
So that's what they're saying.
Yeah, I understand.
Okay, so that's
and I'm even fine with it.
Yeah, we all know. And then, by the way, just now that the hearing is over, and you can also fact check this, they now at the end of the preliminary hearing dropped like an insane amount of the discovery stuff they gave to them like a week after. You guys can give me the exact amount. I don't want to say because I don't know my I don't remember how much it was. It was an absurd amount of stuff that they gave to them right after the preliminary hearing that they had been asking for. Because that was one of the things that I kept saying on my show is, as we were watching that preliminary of the preliminary, why not just give them the stuff now so they can engage in these arguments? Because I feel like you, it's like, I want to hear what they have to say about the text messages. Why can't you just give them what they're asking for so that they can actually engage you? And
because there's a process and a procedure to law, and you don't just do stuff to be nice to people. Like, what do you mean? They're going to do what's required of them.
And it didn't happen. So, but the judge ruled that it wasn't necessary at this stage, and that was the whole point of that
because it's
preliminary to the preliminary. Yeah.
Would you like to play the Kathy video?
Well, he's saying he's not.
But doesn't the legal standard just mean the layman's version of reasonable? No, it had a definition for, it was referring to some other paragraph probably for these are the things that you have to make available to the defense. This is all going to be spelled out pretty close.
Disagreeing, so I don't think we need
There's
to.
there's no disagreement that she said that.
Yeah.
So I guess the disagreements now would move into the evidences that you have stated on the record, which transcend elements of reason.
Why are we having a transcendental conversation now? Because I mean,
because
your entire thing was about looking at the evidence, which never made sense to me. Again, because all of the evidence that you felt to be overwhelming was hearsay. That was bizarre to me.
You told me that I could take as much time as I wanted to question you on these things.
I'm just asking you just to lay the groundwork of what you're saying is problematic. That you decide that it trips into something else. And I do still want to hold you for going through, because we discussed the gun, we discussed your.
You can hold me to those things, but I would like to get into the things that you said. So, and I'll explain exactly what the groundwork is. When you make claims which pass the idea of I'm just asking questions because the state's evidence is not convincing, I think you have to answer for those claims because they are in regards to this case. You're saying I have a claim. It is in regards to the assassination of Charlie Kirk, which is what we're talking about, not just the case of Charlie Kirk, it's assassination. You should have to answer for the claims that you've made in regards to the assassination itself. You should, yeah, agreed. So if that's the case, then I would like to finally dive into some of that evidence and dive into it.
Well, just to be clear, and I'm happy to have you talk about, like I said publicly, you want to engage in some conspiracies, but I said I want to make sure that we get to the substance of our debate. The substance of our debate
is the major
me demonstrating that all of the quote-unquote evidence that you feel that you have, which demonstrates that Tyler Robinson shot Charlie Kirk.
You don't find convincing, I get it.
It's been invalidated by the testimony that we saw, and in your answer for when I explained to you that he had the most degraded prints was, I don't know. Okay, well, there lies my ability to process that.
It's just fine for you to not be convinced up to this point. All of your viewers, everybody watching, nobody's giving you a dispute that if all your claims ever were just up to now, the evidence that the state's given, I'm just kind of not convinced. That is not what's been happening. What's actually been happening is that you've made tons of claims in regards to this case and in regards to the Kirk assassination, which are far above and beyond, I just doubt, the state's theory.
Okay, yeah, I mean, sure. I do doubt the state's theory. I also am welcome to say what I think. You know, if you want to move into opinions, if you want to talk about Erica Kirk, if you want to talk about Turning Point USA,
Like to talk about all
and
of
get
it.
into it, I'm totally happy to do that. But I just want to say that, like, I do not feel, because I've said what's important to me is that we exhaust this topic first of our actual debate claims. I do not feel that you sufficiently have argued that the evidence is overwhelming.
Sorry.
Question for you.
that
What-
Tyler
But I am
Robinson-
sorry you feel that way.
Candace, one question. What evidence do you need to see for you to say Tyler Robinson killed Charlie Kirk?
That's a great question. So I actually expected in this preliminary hearing, actually, almost the inverse of what he was saying is true, right? So this is now the time the state is putting on their evidence. That's the purpose of this hearing, right? The state is using hearsay, but they're also putting on their evidence. So I was just expecting some sort of a slam dunk. Like, we got him on camera taking the shot. At least we have him clear on camera. You're telling me
If fuck, I wish I knew what the I don't know what the hearing was for. If it was only for indictment stuff or probable cause stuff, depending on what the hearing was, they don't have to put all their evidence out. I think sometimes you might fight over what can be entered, or what can be not entered into the record, but like what can be presented at trial. But if there's something that the opposing side's not disputing, then I don't even know if you fight over it. It's just accepted. So you might not see every single thing in these preliminary hearings that you would expect to see at the trial itself.
this guy drove 13 hours all around. Like, we can definitely show you a picture that it's going to be beyond a reasonable doubt before we even get to the trial. People are going to see and go, oh crap, like it was really Tyler Robinson. I was expecting to at least see evidence that, because I had reported early on that the source was saying that Tyler did not step foot on campus that day. It is my perspective that he had something to do with something. I do believe he was disposing clothes at this stage. At this stage, I do believe he was disposing clothes. He was involved somehow. I find Lance to be more suspicious, if I'm being honest with you. And also, like I said, the use immunity that was given to Lance by the feds, the fact that the feds didn't ask him any questions, the fact that I spoke with Lance Twiggs' family, and they were like, it's very weird that the feds are not asking him more questions. He's exactly the person that I would imagine to be involved in some stuff. Allegedly, I'll say allegedly. But when we got to the preliminary hearing, there was not a single piece of evidence that I felt was slam dunk. I was waiting for that, a photo. I mean, anything would have made me go, all right, I think this could be the guy. If they had handed over the discovery on the text messages, since that was their big, ta-da, we've got the text messages, that would be the first thing that I would hand over. But actually, who was holding them up, like I said, it wasn't the prosecution. They're right to say we were handing things over, and we heard the defense argue on behalf of the prosecution, saying it's not them, and it's not the FBI, it's the FBI that's holding on to things. The FBI took everything. The FBI took the gun, the FBI took initially the screwdriver, and then when I heard testimony about the things that they found that were suspicious, example being the backpack, that's something that really bothers me, that they say they traced the shooter, they traced the route that he went on, and then there was an abandoned, we know it looks like he's wearing some sort of a backpack. We know that there was an abandoned backpack found at the bus stop in front of a library, and they felt that this should be taken into evidence. They took it. The FBI, this was a testimony of Amanda Baker, I believe her last name is, but you might want to fact check that because I think I'm blending last names. She was the forensics for the FBI, and then she says she gets a call on the 13th, and they stop testing on this backpack because they find that the backpack actually belongs to somebody on Charlie's team. But if you know the map of the layout of the campus, you're going, well, what the hell were they doing all the way up? This is nowhere near anywhere. And by the way, that's not an acceptable